Hello, everybody, and welcome to History/Law Bite number 177, dated February the 6th, 2021. I'm Walter, your mobile historian and blue-collar scholar. This History/Law Bite is entitled Sipuel versus Board of Regents of the University of Oklahoma, 332 U.S. 631, 1948. Sipuel versus Board of Regents is a very important U.S. Supreme Court decision in the very early years of the civil rights movement in the United States. In this case, Miss Ida Sipuel was a young African-American woman who, upon completing her college studies, wished to attend law school in her native Oklahoma. As such, she applied for admission to the University of Oklahoma's law school, the only law school in the state. Unfortunately for Miss Sipuel, the University of Oklahoma's law school did not accept African Americans as students. Okay? So, when she applied, she was, of course, rejected. Now, many people would have just given up or just applied to another school out of state, but Miss Ida Sipuel was not about to do either. Indeed, she sued the University of Oklahoma, citing that she had the right, under the 14th Amendment to the U.S. Constitution's Equal Protection Clause, all right, an existing Supreme Court precedent, that she had the right to attend this school, all right, as the court had required a decade earlier in the case of Gaines versus Canada, which is covered in its own separate video, that when there's only one school in the state, all right, in this case specifically we're talking about law school, when the state only has one specific school for a particular type of education, then it would have to have admitted Miss Sipuel to the school for studies as to be in compliance with the 14th Amendment's Equal Protection Clause. It was either that or build a separate school for African Americans. All right. In this case, that wasn't even on the table. This was the only school available in Oklahoma for her to attend, and this was the one she wanted to attend. Okay. And that's what her lawsuit contended, that she had the right under the Constitution and existing Supreme Court precedent, all right? Unfortunately, she lost at the district court level in the state, and that defeat was affirmed by the Supreme Court of Oklahoma. As such, her attorneys petitioned the U.S. Supreme Court by way of writ of certiorari to review the decision of the Supreme Court of Oklahoma. After only 4 days of deliberation, 4 days, which is very quickly for the Supreme Court to provide a decision, the court ruled unanimously via a per curiam opinion that Miss Sipuel had the right to attend the University of Oklahoma School of Law. All right. And indeed, in a greater sense, the court's decision affirmed and required that black students, had to have an equal opportunity education provided by the state in the same way that whites did. Translated and all boiled down, blacks had to be afforded the very same educational opportunities by the state as the state gave whites. Point blank. End of story. All right? The justices essentially didn't have to do much hard work on this case, as indeed, as I mentioned earlier, all right, existing precedent from the case of Gaines versus Canada 10 years before this decision ruled that when there is only one particular type of school in that state providing that type of education, then the state has to admit all qualified applicants regardless of race or build another school for those you don't want there. All right. As the University of Oklahoma wasn't about to do that, it gave in and admitted Miss Sipuel to the school to study law. Interestingly enough, with this case, and you didn't see this a whole heck of a lot throughout the South, a lot of the people that Miss Sipuel attended school with were very, very opposed to the law forbidding her to attend. And in fact, she was very, very, very successful and brilliant student. You know, she made a lot of friends at the school. All right, that certainly would serve to help her down the road. Another interesting tidbit about this case, I know it's not one you hear about very often, Sipuel versus Board of Regents, but one of her attorneys in this case shouldn't surprise you at all, was the legendary Thurgood Marshall. All right. In one of his books, former U.S. Supreme Court Justice John Paul Stevens indicated that he was sitting in the gallery when this case was argued before the court in 1948. And he described Marshall's arguments as passionate, very knowledgeable, and certainly very persuasive. And obviously that all had to be true because it only took the court 4 days to reach a unanimous decision that the decision of the Supreme Court of Oklahoma was obviously in contradiction with the Constitution of the United States, and that Ms. Sipuel had the right to be admitted to the only institution in the state of Oklahoma which happened to be all white, in order for the state to be in compliance with the 14th Amendment to the U.S. Constitution. So, like I said, she was admitted to the school accordingly without opposition. All right? So, this is Sipuel versus Board of Regents of the University of Oklahoma. And the essential holding of this decision was that the states must provide equal educational opportunities to blacks in higher education in the same way that it afforded whites. All right? So, any questions or controversies, leave them down below, and I'll be happy to answer them. If you have not subscribed to my YouTube channel, please do so now. Just hit that little red subscribe button and that little bell, and we will be in business. All right? Again, any questions about this decision, which isn't often heard about because it was succeeded by a whole lot of other more prominent decisions, just leave them down below and I'll be happy to answer them for you. Take care, stay safe out there, and I'll talk to you at the next bite. Peace.